Alex here with part 59 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video with the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the underlying purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off with a stipulation and order. That was supposed to be the end of the problem, at least the problem with regards to exchanges and visits. But as far as progress that has been made in the other area, which is medical care, more like denial of access to medical care, medical, dental, vision appointments, there's been quite a little saga on that end as well. We are right back, not where we started, but right back on that path again in this video. This time we were able to go to an appointment together, and you know how I've described high conflict parents as exercising their parental rights as obnoxiously as possible. That's kind of what happened at this appointment. And I think in and of itself, just this one incident probably wouldn't have triggered a response from me. But the fact that, number one, I had to file a motion just to get knowledge of these appointments. Number two, I had to file a motion just to get good notice of these appointments so I could go to them. And then number three, we went into the other problem with the medical denial of access to medical care. All of that combined, and what did happen at this particular medical appointment, was enough for me to just go right back to court and file another motion on the problem. So there were two things that she did at this appointment. The first thing she did was created a scene. She didn't want me to sit near her, and I want to clarify what I mean by that. It wasn't a problem for me to not sit next to her. I didn't want to sit next to her either. But she actually had a very specific, I guess you could call it an instruction, may as well have been a command. She sat at one end of the appointment area, and she said that I needed to sit at the far end of the appointment area. And that still, in and of itself, wasn't enough of a problem. It was the fact that she brought her significant other and wanted her significant other to be present at appointments as well. Now, at this point in the process, the use of the significant other has already been talked about a little bit. I mentioned this at exchanges, like we had problems with the exchange at like the Denny's and the Wendy's for her and her significant other to come and take intimidating stances. But it's going to start to pick up a lot more now as we continue through the series. I can't say that it's going to get worse in the sense that her significant other is always as obnoxious as her, because it's not true. Sometimes she would have a significant other who's actually very nice and accommodating. There were actually a couple that I remember that made life a whole lot easier. But at this particular point in the process, I felt like I didn't have any rights in reality. So let me clarify what I mean by that. I had de jure rights, or rights on paper. Like on paper, the court had made it clear that I was to go to these appointments, I was to have a certain amount of notice, I was to be involved. But in reality, despite what my rights were on paper, de facto, which is the counterpart of de jure, de facto, I really didn't feel like I had any rights, because she was doing all of these things to try to frustrate them. It wasn't that the court had ordered that I didn't have the rights. It was that she would take certain actions to basically deprive me of those rights on her own without the court's approval. And I felt as though this experience at the hospital, or not the hospital, at the appointment, was just a continuation of what was already going on before. Now, the solution that I propose in this motion is really what's going to underline the fact that I really am to the point where I'm at my wit's end, and I am willing to do whatever it takes to have some kind of right to be involved. And what does whatever it takes mean? Well, it basically meant me coming to the court in this motion and saying, you know what, I'm willing to just give up half. I'm willing to give up half of my rights with regards to medical appointments, dental appointments, etc. I'm willing to take turns with her. I can't recall now if I offered to take, no, that was last time. So last time I offered to take turns. So I would go to an appointment, then she would go to an appointment. This time I actually offered to just completely split our rights. So I offered, if I remember correctly, we'll check the paperwork in a moment, but I remember offering for her to have all rights under medical care and for me to have all rights under education. And I've talked to a lot of people about this, not just my viewers, but people who are, personal friends and family, about why I wanted to do something like that. By the way, it didn't end up happening because the court denied my request, and so the insanity will continue. But the reason why, I kind of stated it earlier, I felt like the way the situation was set up, I didn't really have any rights at all. Or I had maybe 5% of the rights that I should have. Because on paper, I had joint physical and joint legal custody, but in reality, she was doing everything that she could to keep me from appointments, to give me notice at the last minute, to frustrate the situation when I would go to appointments. And I can't recall now if this was one of those embarrassing situations, but there are a number of embarrassing situations that are coming up in the case where she does crazy things at appointments. And the only way I can describe this to my viewers in a way that makes sense without going into an essay is to say that people would look at us like we were the weird family. And people would look at our son like, oh, I'm so sorry for this little kid who's got these crazy parents. And whatever actions it was that she was taking, they were various and they were plentiful. That's the perspective, the perception that people, medical professionals, and anyone else who really observed us would have of us. And towards the end of the case, I think I described this as an embarrassment to my son. It was like embarrassing for him, not just like factually, but like you could see it in his eyes as he got older. When he was older, he could tell that people pitied him and thought, she was weird. And usually they thought both of us were weird. People wouldn't try to analyze our case or our situation. They just think we were the crazy family. And this is kind of the beginning of that particular conduct. And I think I've referred to this before as hostage taking. High conflict exes, when, there's all sorts of mechanisms at their disposal when it comes to frustrating you. But one of them is they'll hurt the child to hurt you or to get what they want. That's actually a better statement. They basically have this stance of, you're going to let me have what I want or I'm going to mess him up. And it didn't necessarily mean physically beat him, but it could mean, I'm going to embarrass him. I'm going to make him look bad. It's strange because it also makes them look bad, but I've described this before as how they're willing to sort of cut off their nose to spite their face. I think I've even described it as when it comes to changing that phrase into, hurting you, putting a scratch on your cheek to chop off, or chopping off their left arm, right leg, taking out an eye just to put the tiniest scratch on you. I think I've described it something like that in the past to really underline just how much damage they're willing to do to themselves just to land the tiniest hit on you. Anyway, it's really going to, I think, come out in the paperwork. So I think at this point we can go ahead and take a look at what I filed. Here we have the motion for delegation of parental duties, and the first paragraph, I go into identifying myself as a petitioner. I indicate to the court that I am appearing in proper person, and one thing I want to mention is that it's probably more appropriate to call this a motion to modify legal custody. I say more appropriate because it's just probably what the court would be expecting from any attorney who was filing something like this. Being a non-attorney, I didn't really understand that. I figured a modification of legal custody was changing from sole legal to joint legal or vice versa. But when you're trying to modify the way that the legal custody rights are to be, I guess you could say, assigned between the parties or divided up between the parties, it's almost the same thing, if not the exact same thing, as far as what the court sees or expects. So probably would have been a better idea to title this a motion to modify legal custody. Going into the factual background, first assertion is basic summary of what's going on between us. We share a common child of age 4, and that's next paragraph goes into the other part of, I guess you could call it the summary, which is that we separated in 2008, primarily due to her mental health state and attempted suicide. I have the exhibit, which we've already gone over a number of times in this case. Actually, we've only gone over it once, but we've seen it referenced a number of times. And next assertion is that a final attempt at mediation was attempted and failed utterly. Exhibit 2, I think that is some kind of document from the mediation office, but I'm not sure. We'll take a look at that when we get to it. Next assertion here is that we share physical and legal custody. Next assertion after that is that after I was awarded, or I guess you could say both of us were awarded joint physical custody, I requested medical information regarding our son, and she stated I was only entitled to give him emergency care. So it looks like I'm going through the history specific to the denial of access to medical care, which, by the way, I have a video on that topic. But that's actually good that I did this. Rather than bringing up every single thing under the sun that's going on in her case, I focus specifically on the facts and the procedural history that are where the context is the denial of access to medical care. I'm not bringing up anything else besides that sort of, I guess you could call it a thread, because it's something that's been ongoing in this case. There's at least 2, possibly 3 motions that have been filed with regards to this problem. Next assertion is that she filed an opposition to my motion. The one after that is that the court ruled in my favor, ordering her to turn over the medical information that I was requesting. Next assertion after that is she refused to cooperate. Even, despite the court ruling in my favor, she refused to cooperate. So I had to file a second motion, which is the motion to set procedure for appointments. My ex again filed opposition, this time alleging, oddly enough, that I did not want to attend appointments. The next assertion here is that the court ordered a review hearing and that we appeared. Okay, so I've gone over this already. Of course, I mean, this is an incident that's already behind us. There is a video on this review hearing if anyone wants to see it. I can't remember what part of my Docket series it is now. I think it's possibly part 49, but I've sort of spaced that. But yes, this hearing, the court admonished her for refusing to schedule appointments as clearly as required pursuant to the court's order, and requires her henceforth to give me 14 days notice. To date, she has not given me access to her mobile phone. She refuses to reciprocate, alleging that I abuse the right to call her on her mobile phone. Next assertion here is that dental appointment. Okay, so here we go. She actually did give me notice for this dental appointment. I did make an appearance at this appointment, and this was, okay, I stated right here clearly that this was our first post-separation appointment. So I'm going to, again, this is all fuzzy, going back 10 years, but I'm going to assume that prior to this appointment on October 10th, 2010, we had not had any appointment where we both made an appearance at. This is the first time. She refused to allow me to sit near him, held him in her lap, and threatened to make a scene in front of staff. This is something that is just now coming out for the first time, I believe, in my paperwork, but does continue to occur all the way up until years 6 or 7, at which point the court actually bans her from making appearances at appointments. But this is the beginning of a very long and continued, I guess you could call it, strategy by her to make it very unpleasant for me to go to these appointments. That was her objective. Once she was ordered on multiple occasions to make sure that it was possible for me to go to these appointments, she fell back on her backup plan, which is to just make the appointment as unimaginably embarrassing as possible. Going into the argument, the court can't force us to cooperate. I really wish more courts would realize this. If there are 2 parties who will not cooperate, the court cannot force them to cooperate. The best thing that the court can do is pinpoint the non-cooperative party and deprive them of their custodial rights. That's the best thing they can do. Otherwise, we end up going into Mazda v. Figliuzzi in Nevada, which cautioned that to reward the high conflict party that's refusing to cooperate is just going to make them and others deliberately, on purpose, not cooperate so they can get what they want. And in the Mazda v. Figliuzzi case, it was a sole custody award or a primary physical custody award. I can't remember now, but same problem here. If you let somebody create conflict if you let somebody refuse to cooperate and then turn around and point out to the court, I should get what I want because of the non-cooperation, you're basically sending a message to them. Yeah, don't cooperate with your ex, because if you don't, you're going to get what you want. So anyway, I'm bringing that up, and I think I cite Mazda Citation later down in this document, but that's exactly what I'm trying to tell the court here in that first paragraph. Next paragraph is that she has arbitrarily exercised her discretion in the gray areas of previous court orders in ways that exclude me from being involved in our son's medical care. I actually have a video on this topic. It's called Gray Areas. I would love to talk about it more, but since I dedicated a video to it, I just advise my viewers to go and take a look at that video. Next paragraph here. Court's affirmation and increased levels of specificity in successive court orders has only been met by increased levels of subversion and sabotage by my ex. This is something that I've kind of got an epiphany, a really strong, I guess you'd call it change of heart, change of mind maybe, around years 6, 7, 8 of my child custody dispute. Prior to that point, I always recommended that people do everything they could to make sure that orders were put together such that they didn't have any gray areas in those orders. I always imagined that that was the best way to approach these problems, but now I don't. Now I imagine the best way to approach these problems is to modify custody. If your ex is trying to exploit gray areas of the court's order in ways that are damaging to the child, the best thing that you can do is deprive them as much of their custody as possible, not try to clarify those gray areas of the court's orders. And the reason why is because they're doing it on purpose. If you have a person who's on purpose finding and exploiting gray areas, they're going to continue to do that when you give them another court order. They're going to just find other gray areas to exploit. It's one thing for somebody to sincerely be confused by a gray area in the court's order. It's another thing entirely for a person to seek them out and weaponize them. Next, we have a citation to Mack v. Ashlock, which is that the sole consideration of the court is the best interest of the child. That's true. I'm not sure if people still use this case much in Nevada. Next, this citation is to Rivero v. Rivero, which is a publication where the Supreme Court states clearly that both parents need to have equal decision-making power in a joint legal custody situation. Next paragraph here, we go into Rivero again, which dictates that the public policy of the state in child custody matters is the best interest of the children, namely frequent associations and a continuing relationship with both parents. So I'm just underlining Nevada precedent on the importance of the best interest factors and on the importance of both parents being actively and frequently involved in the child's upbringing. Here we have that Mazda citation I was just talking about a few moments earlier. You can go ahead and take a look at this case if you want to, but it basically states what I already stated a few moments ago with regards to not rewarding uncooperative conduct. Next paragraph here, Mack v. Ashlock again. If the court makes a finding that de facto cooperation does not exist in this case and that I have been excluded from his healthcare, it would be appropriate to respond by delegating parental authorities, which is what I'm asking for. I think I stated this earlier in the video, but if not, what I'm asking for is the division of legal custody rights. You know what? We'll go over it in this. Further on in this document, it's going to come up. Consideration of the best interest of the child specifics. It is appropriate to award decision-making power regarding education. Oh, it's already up here. Okay. Decision-making power regarding education to me and decision-making power regarding healthcare to her. She's already established herself as his custodian regarding healthcare, basically unilaterally, and she's been setting and attending his appointments since the separation. So I think that the best thing is for the court to give me full authority on education. Should she attend... Oh, I see what I'm saying here. I'm making exceptions. If there are healthcare appointments that are life-threatening operations, she should be able to come to those. And if there are educational situations, like, for example, a graduation, she should be able to come to that, vice versa. So, I mean, what I'm trying to say is that in education, if it's like one of those really important situations like graduation, that's something we should both be able to go to. And with healthcare, surgeries and serious stuff like that is what I should be able to go to as well. Not that it's going to make it any different. I do believe that she would have still done the same thing that she had been doing throughout the relationship, throughout the separation, at one of those types of situations, like at a graduation or at a surgery. But I figured that the court wouldn't want to preclude us from going to that kind of serious, high-level stuff, even if it did delegate these authorities or this decision-making authority. Next, we have a hearing, or I'm not requesting a hearing on this matter. I talk about this quite a bit throughout the series. I'm going to try to space my discussion on this out. It is a very important area of this document that I just handled with a single sentence that does not do it justice at all. But if you've been watching the series from beginning to this point, you should have already heard my spiel on what this little area of the paper is actually talking about. It's not so simple as just getting a hearing because you want one and not getting one if you don't. It's much more in depth as to when you get an evidentiary hearing and when you don't, and as to what a law and motion hearing is versus an evidentiary hearing. These little details matter a lot. I cannot underline this enough. Please try to watch a series from beginning to this point, or from beginning to end when we actually get to the end. In the conclusion, I am requesting that the court order a delegation of parental duties regarding healthcare and education. Affidavit, as mentioned in many of my previous videos, this is required by the rules of the court, and the reason for it is that all of the factual assertions that I have made in this paper need to be backed under penalty of perjury, need to be made under oath, and that's what this affidavit does. By the way, you can support a motion with an affidavit from another person, but I think 99 out of 100 times the attorney, well, in this case I'm representing myself, but typically the person who prepares the affidavit is the actual person who's filing the document. Motion opposition notice. Now, if this was titled a motion to modify legal custody, as I mentioned at the beginning of this portion of the video, I do believe that I would have ended up marking these checkboxes differently and that I would have ended up paying a $25 filing fee to file this motion. But I didn't understand it at the time. I didn't know. And for all I know, what I've done is fine. I'm just suspecting now, 10 years later, as I sit here and do this video, I am suspecting that I possibly did not fill this out right and that it should have been filled out in a way that resulted in me paying a $25 filing fee for filing this. Affirmation, which is going to basically state that this document does not contain a social security number. It's one of the things that the clerks of the court look for so that they can make sure, well, they don't really make sure that there's not a social security number in there, but they take your word for it and they look for the signature line. List of exhibits. Exhibit 1 is the police report that I've already gone over, so I'm not going to go over that again. Exhibit 2, mediation. Exhibit 3, email. These two things that wait a minute. Affidavit? Okay, well, let's take a closer look at that. I thought it was a letter, but according to this, the mediation exhibit is actually an affidavit, so I'm going to take a closer look at that. Anyway, as with my previous documents, if you want to look over this, as with my previous videos, if you want to look over this set of documents, you can go down in the description below, and there will be links. You can click on that link, download this document, and take a look at it yourself, including the police report that I'm about to skip over. But it's not a big deal if you've been watching this from beginning to now, because you would have seen my analysis on this police report in detail, probably in part 2 or part 3 of the My Docket series. Exhibit 1, here's a report which we'll skip. Exhibit 2. Here is the affidavit. Okay, it would have been better for there to be some kind of document from the Mediation Services Center, but I guess this is the best I could do. We attended mediation twice. Maybe I tried to get this exhibit and then I couldn't, so I figured at the last minute I just would prepare an affidavit. It makes sense because I hand wrote it in with pen. So, by the way, guys, there are, at least in Nevada, actually not even statewide, at least in Washoe County, there are rules, local rules, that require a court to not set mediation under certain circumstances, and I started to use those later on in the series. I highly recommend using those. If you have a rule like that in your district or in your state that can get you out of going to mediation with a high conflict ex, I strongly recommend it. It's the thing about high conflict exes is they don't want to settle the case unless they're forced to. So they don't want to voluntarily settle, but they will settle if their arm is twisted hard enough. And mediation is not that opportunity. Mediation is not litigation, at least not in Nevada. Mediation is where you have a sit down and you actually try to work things out in good faith. And they don't operate like that. So they'll use mediation in other ways, to denigrate you, to make fun of you, to belittle you, to emasculate you. They'll use the mediator as just an extension of the judge. They'll treat the mediator like a judge and try to get the guy on their side. And so it's not a constructive process at all with them, with high conflict exes. Exhibit 3 is an email. It looks like a pretty big one. Okay, so I'm not going to go through this entirely. If anyone wants to take a look at this and post something down in the comments below, I'm much more open to that. This looks like an essay she sent me. Okay, so is there anything relevant to this document? I'm going to take a quick look here. She's explaining why she won't give out her number. By the way, all of this is provable, guys. If I was texting her Leaving voicemails, she could have produced that and brought it up to the court. She also has a right to record me. She spent all this effort, and her attorney, well, she and her attorney spent all this effort to try and get permission from the court to record me anytime they wanted. They got the permission to do so. They can record me anytime they want, and they never produce a recording. So, let's see here. She's basically just trying to make statements that aren't true and justify what she's doing. So that I didn't show up, that I changed my mind right before, that she's changed her plans. I don't know what she's talking about here with the designation. I don't think that this has to be reported to the court. No, we'll just clutter the docket. She's talking about not getting shoes back. I highly doubt that. None of these allegations are true. I'm trying to avoid things that don't have anything to do with the motion. Again, just post something down in the comments below if you have something more specific to... If you want to talk more specifically about this email, post something down in the comments below and I will. It's too long. Something about homeschooling him. I'm not sure why this is even coming up. Eventually, the education is going to be resolved. So here's my email. It's a lot shorter. It's very straightforward. If she's late, she calls me and I wait. If I'm late, she keeps her number secret so I can't call her. And then, rather than call me even restricted, she just leaves. This is me upset about the 1 minute late thing. I don't know, that it might be a bleed over. At the very least, she could call me and see that I'm a minute away. I'm not sure why this is coming up in this filing because it was resolved. Well, I guess it's because it's all in the same email thread. So that does make sense. Violating the court's order. 2 additional vacation time. Okay, so yeah, this was already resolved and we already got a stipulation out of it. So wow, despite the fact that she sent me this gigantic thing justifying why she did what she did, she still caved in the end anyway. She gave me the 2 days vacation, or the 2 days makeup time. We already went over that. The stipulation and order was already entered on this. But this is one of the things that happens with high conflict X's. You send them a very short email with some straightforward things that need to get resolved, and then they send you a gigantic essay pointing out all these other things and characterizing you in ways that aren't true. I think it's because she wants me to respond to her response, defending myself, which then continues this into just... These can continue into a 50 or 60 email thread. That don't do it, guys. Watch my video communication. As you can see, what I did here was simple. I sent her this short email. She sent me this gigantic response, and then I filed a motion. And then in the end, she caved and entered a stipulation. So again, watch my video communication and also watch my video failing to agree, because I go over how to deal with this problem pretty thoroughly in those 2 videos. Proof of service. This here is my certificate that's filed indicating that I personally served the motion for delegation of parental duties upon my ex's attorney. Personal service means I physically went to her law office and handed the papers to the lady working behind the counter. I think that's it, just 1 page, yeah. Next we have the notice of vacation and time limit to respond. What is this? So I'm telling her that I'm claiming certain vacation days and that she has a duty to respond? She has 10 days to respond to my motion. Oh gosh, I didn't have to do that. The rules of civil procedure tell her when to respond to my paperwork. I bet you that I put this in here because of that previous incident. I do recall when we went over the stipulation and order in the My Docket series that recently occurred, I ended up filing a request for submission because I was sick of waiting around for my ex's attorney to file it herself. So maybe I am still upset about that and I'm letting her know, hey, you have 10 days to respond to my motion, otherwise you're in violation of DCR 13.3. You don't have to really put that in there. And the other thing that I want to mention is you don't have to really file this in the docket. If I'm going to make a notice of vacation, I can just send my ex an email. Filing this in the docket is just going to clutter the docket and it's going to annoy everyone. Okay, and same thing, affirmation and certificate of service, this time by mail. So this document I did not give her personally. This document I sent to her in the mail. Going into the aftermath, I filed the motion for delegation and the proof of service. Both of those were free filings, at least according to the motion opposition notice that I filled out. So that would be $0 in costs. My ex's attorney, well, I also filed a notice of vacation. So my ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably put, I'm going to say 25 minutes into reviewing that motion. I think I'm going to put more of her time with regards to conferring with my ex and coming up with a strategy on how to oppose it in the actual opposition, which we'll go through in the next video. So I think 25 minutes to just review the motion and nothing else is reasonable. And then 5 minutes for the proof of service and notice of vacation, which is going to bring it to 30 minutes. That's a half hour at the rate of $250 an hour. That's going to be $125 in attorney fees for my ex. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.